took certain steps. So, my Lord, clearly the answer of the first respondent shows her recognition that the issue of her bias is part of what has been pleaded. And she is asserting in paragraph 40 that she did a first respondent, well, in fact, respectfully, that paragraph just says the first respondent. It doesn't speak specifically about her. So we should take the words as they are. The first respondent says it's complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias. So clearly, there is an issue that is before this court of whether there is bias to anyone or in favor of anyone or not. There is an issue.
So, Mr. Tsikata, where in your pleadings did you plead that there is bias because the first respondent, in a way, is related to the wife of the second respondent? Right.
My Lords, we plead the 296B bias by either by resentment, prejudice, or personal dislike.
By the use of pleadings, we don't plead law. We don't. 296 is the constitutional provision.
Yes. My Lord, we plead law in the context where certain facts related to the operation of that law are being contested, because we have to state that the Constitution has this requirement in order to point out that that requirement has been.
But then they went further, as you rightly pointed out in, I think, was it paragraph 40? Yes. And then they pleaded in answer that they complied with the law and that they were not biased, and they went to with the due process as required by law. So yes, but then if you go further and we are concerned with the last paragraph of paragraph 26. We are not comfortable with that.
That is their problem.
That is their problem.
The paragraph starting from the chairperson of first responder, Mrs. Adukoya-Mensah, allowed herself to be biased by her prejudice in favor of the second responder, who appointed her in August 2018.
Yeah, that is
with whose wife, Mrs. Jean Adukoya-Mensah, has a close familial relationship. Mrs. Mensah was asked at all material terms in the conduct of her responsibility, biased by prejudice in favor of the second respondent and against the petition. They are saying that this has not been pleaded. This fact, this evidence, is not based on the pleadings.
We are saying respectfully that what is contained in the witness statement is evidence of the pleading of non-compliance with Article 296. Because that is part of our case.
No, you must plead before. I mean, the thing does not even appear in your pleadings. So how can it come to become evidence? The thing does not appear in your pleadings. We have not read anything like this from your pleadings, from the petition.
Don't you think the close familiar relationship should be a material fact that based on Order 11, Rule 7, you should include in your pleadings?
My lords, I am not of the view that that by itself is a material fact that should be reflected. And my lord, let me be clear. Bias could be related to a number of different factors. A close familial relationship is a potential element. And if, in spite of the close familial relationship, there is action taken that reflects due process, transparency, and everything, then in that situation, the close familial relationship will not affect the conduct of the proceedings. So it is really a matter of evidence whether in the context, in the circumstances that we're dealing with here, whether we have a situation in which that familial relationship has actually affected
This is your evidence. This was not in your pleadings. This was not in your pleadings. Are you not taking her by surprise?
Well, we don't believe that this takes her by surprise because this, I'm sure, is
No, I mean, legally.
there are facts that are very well known to her. In fact, there are facts that are.
Well, we don't know. We sit here, we don't know. Until we read this, we didn't know.
Okay.
Okay.
My Lord, we are saying that in respect of paragraph 26, I'm concluding my response on paragraph 26. Am I allowed to do that? We are saying that in response to paragraph 26, these allegations of bias are sufficiently referenced in our pleadings in relation to the operation of Article 296B. The denial that is contained in, and we're saying that the denial that is contained is not taking the first respondent by surprise. Paragraph 40. That in respect of the allegations of bias that indicate that statement. The petitioner is not taking the first respondent by surprise in respect of in paragraph the allegations 28 of bias that are in the witness statement. I understand that the objection is to a portion of that paragraph, and if your lordships could clarify which portion. I understand that and lack of transparency. The objection is to a portion of that by one or more officials of first respondents seeking to justify after the event, Mrs. Jim, the secrecy December and lack of transparency regarding the declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration and shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast. My lords, I have referred already to our pleadings in respect of transparency, and I have also referred to our pleadings in respect of these changing figures. And if I may go over that again for the purposes of this response. And we start from paragraph 8. The claim that the percentage of votes cast, votes obtained, paragraph 8 of the amended petition. The claim that the percentage of votes obtained by second respondent was 51.595 of the total valid votes that she herself distinctly stated to have been 13,434,574 was a manifest error, as votes cast for second respondent would amount to 50.098 and not the 51.595% erroneously declared. And then in paragraph 12, which I referred to before, we indicate that if the total number of votes standing to the names of each of the presidential candidates is summed up, this would yield a total number of valid votes cast of 113,121,111, a figure that is completely missing from the purported declaration by Mrs. Jean Aduko-Mensah on 9th December 2020 and the purported rectification on 10th December. So we have already intimated these initial changes. And then we proceed, as I indicated previously, we proceed to make reference to the fact that this is in paragraph 22, which I referred to before. Mrs. Jean Aduko-Mensah predetermined prior to the 7th December 2020 presidential and parliamentary elections that she would announce the results within 24 hours after the close of polls. Consequently, she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. Prior to her making the said purported declaration, Mrs. Jean Aduko-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of those concerns, and the letter is attached. And then we also further indicate the lack of transparency that was involved in the purported corrective press release. And this we do in paragraph 30, in seeking to justify the new figures put forward in the press release. Various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. There's a direct reference to the lack of transparency in that paragraph. And we go on further in paragraph 31 to say that the so-called rectification of the errors in the purported declaration was itself egregiously wrong, and we go on to provide. So, my lords, in paragraph 33, if Mrs. Jean Aduko-Mensah, as returning officer of the presidential election, had determined in good faith that her declaration on 9th December 2020 was in error, her constitutional duty to be fair and candid, and my lord, that explains why we had reference to the constitutional duty in the pleadings. That her constitutional duty was to be fair and candid required her, among other things, to acknowledge the error, set aside her erroneous declaration, and proceed on the path to correcting her error, respecting the rights of candidates to participate in the processes towards the making of such a declaration. So we indicate what transparency required. We didn't just say lack of transparency at large. And we go on in paragraph 34 to say that the unsigned press release of first respondent has no value in the determination of the validity of the declaration that Mrs. Jean Aduko-Mensah made on 9th December 2020, especially as the issue of the release was not undertaken transparently and in accordance with due process of law and established practice, including the participation of affected candidates through their respective agents. So we have pleaded everything that we need as a foundation for pointing out that what was done secretly, in the sense that it was done, without reference to any of these candidates, completely by themselves, and not in accordance with the legal requirements for the participation of agents of the candidates. I mean, all these paragraphs that I've adverted to are specific in reference to lack of transparency, lack of contact, consultation with anybody. And my lords, I mean, I cannot see how the witnesses' indication that the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondents seeking to justify after the event Mrs. Jean Adukoya-Mensah's 9th December purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual votes cast in the presidential election for the various elections, for the various candidates. So, my Lord, the point we are making is that there has been sufficient basis laid in the pleadings for there to be evidence that shows that figures were just being cooked, because the figures are coming out of nowhere and without reference to anything that is transparently communicated to anybody. My Lord, with the greatest respect, I find it very difficult to see how any objective observer of the ever-changing figures that have been put forward can fail to see that we are not justified in talking about figures being cooked. And my Lord, figures being cooked is simply an indication that the figures are, just being thrown up, unrelated to valid votes being cast, counted and collated, which is what it should be. So, my Lord, respectfully, we would submit that
for a magazine in 2030.
There is a basis in our pleadings about lack of transparency, lack of due process.
1969.
In respect of paragraph 30,
his job as a sum up the life of our
and if your lordships could again perhaps read out what the ground, the specific ground is, so that.
Thank you very much.
Asking for help with paragraph 30.
Yes.
A divine
The whole of the paragraph. On the basis that
do something. Thank you very much, Mr. President.
Joshua of the legislation referring to
Okay, my lords, this again is not a pleading of law at all. This pleading states in the new regulations promulgated, and it's not an issue about the validity of the constitutional instrument. That is not the issue. In the new regulations, this is just a factual statement about how the new regulations operated. In the new regulations promulgated by first respondent, CI 127, it now interposed between the strong room and the constituency collation centers, without any good reason, another layer of collation at its regional offices with regional summary sheets. That is a fact. It did that as a result of the constitutional instrument. This led to results being sent from regional collation centers which were at variance with the results collated at constituency collation centers as a result of figures being altered by officials of first respondent. Exhibit C provides sample details of wrong aggregation of valid votes on the face of the summary sheets of some 11 constituencies. The exhibit shows that the sum total of votes, of valid votes obtained by all candidates varies from the figure recorded on the face of the summary sheets as the total valid votes from each of these constituencies. Now, my lords, the statement there is quite clear about the interposition of the regional collation centers as a source of errors. And an exhibit, Exhibit C, is also provided. In the petition with the sample details. Now, my lords, it needs to be clear. It needs to be clear that in this petition, unlike perhaps in the 2012-2013 petition, the petitioner did not come to court saying that another 4 million votes of voters who have voted are now them because in some cases pink sheets didn't have presiding officer signature or there were duplicate serial numbers. That, in the nature of this petition, the petitioner is saying that a certain declaration was made on the 9th of December. It was publicly made, we all heard it, and the petitioner is saying that when you look at figures in that declaration itself, those figures do not amount to compliance with a constitutional provision duly. That's what the now, in this paragraph 30, what the petitioner is seeking to do is precisely to provide, as it is said, a sample of wrong aggregation, and the petitioner is attributing that to the interposition of the regional collation center. So that is the import of that paragraph, and that import is related to the lack of transparency pleadings that we clearly have.
Mr. Tsikata,
yes.
Your pleading indicates that that interposition comes from the new regulation, from the law. Isn't that your pleading?
The new regulation is, I didn't hear the last bit of
the testimony of the witness is that the interposition, the
new regulation
interposed, yes.
Yes.
And that's the source of the trouble. That's the source of the complaint.
Yes, in its operation, the way it operated, the way this new regulation was operated in practice.
And the objection is that it seems to suggest that the new regulation of first respondent was about ensuring that the process of collation and aggregation of votes were introduced without good reason. And yet that was introduced through a law. It was a law that provided that framework. And
yes,
that is a complaint.
It was subsidiary legislation made by the first respondent, and the witness statement is indicating that the operation of that, it was a matter of law, but you can operate a legal provision in a manner that leads to wrong results. That's what we're saying. I mean, you could operate the creation of regional centers in a transparent way, which does not lead to the results.
And so once again, you are inviting us to make an inference, or what?
My lords, I'm not inviting just making an inference. I'm saying that we have pleaded a lack of transparency. We have pleaded a lack of consultation in respect of how these figures popped up. And the witness statement is showing one of the ways in which that lack of transparency was demonstrated in the actual conduct of the first respondent. That is what the witness statement is seeking to do as a matter of evidence.
But Mr. Tsikata, there is nothing in the petition about this, let me call them collation issues. There's nothing in the petition that the collation process resulted in changed figures or figures changing.
We have pleaded the fact that numbers were being changed by the first respondent without any transparency.
No,
now,
Mr. Chair,
those
this
numbers,
is such a big issue that if that is your case, it should be in the petition that A, B, C, D, from this polling station to this constituency to this regional collation center, these figures changed. There's nothing about this in the petition.
my lords, the petitioner is not the returning officer for the presidential election.
Oh, but he's the one challenging
the petitioner. May I answer you? The petitioner is challenging, firstly, on the basis that you made a declaration in which you put forward certain numbers. On the face of your declaration, those numbers do not warrant your exercising your constitutional responsibilities the way you did. That is the basic point of the petition. My lords, if I may finish my answer, because I believe it's important for the answer in its fullness to be heard. That the petitioner makes clear that her challenge is based on the fact that the person who is a returning officer, that person has purportedly made a certain declaration of someone as having won the election. And yet the figures that she has put in as the basis of her declaration, those figures do not warrant her declaration. That is the heart of this matter. Now, my lords, at the heart of that petition is this issue about the numbers that were acted upon by the first respondent. First respondent puts forward an answer in which effectively first respondent says, I am actually admitting that there were errors. That's what first respondent is saying. First respondent is saying, I'm admitting there were errors, but one, they were inadvertent. And they were corrected by a press release on the 10th of December 2020. We point out that the so-called correction itself contained mistaken figures. We point that out very clearly. And we further point out that those figures kept changing right up until the point where we have in the witness
My lords,
statement.
with respect, counsel has been repeating the same things for the past 15 or 20 minutes. It's the same thing he's been repeating.
My lords, I don't know whether that's meant to throw me off the course of my argument, but I think with respect, this is intolerable with respect, because I was in the middle of a sentence actually, and you know, it is not appropriate, you know, to make this kind of interjection.
Yeah, please, when you want to raise an objection, it has to be timeously erased. Yeah, so that, yes, you don't disrupt.
My lord, I thought I was actually raising it timelessly.
My lords, I believe I was in the process of explaining that at the heart of the petitioner's petition before this court is a challenge to the declaration. And it's not just a challenge about figures, but it's a challenge related to the constitutional consequence arising from those figures. And we're saying that we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you're supposed to be speaking to paragraph 30, which is about the collation. And the question from my brother on my right was that there is nothing in your pleadings about the collation process.
My lords, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. So the witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through, these 4 stages, and so she is in effect explaining herself in terms of her conduct. And we are saying that on that basis, the witness is entitled, because my lord, if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead him and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? My lord, that's perfectly legitimate if I were leading him in the normal course.
Counsel, in fact, with the greatest respect, my problem is this. In the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127. The law that regulated election.
And the petitioner does not seek to raise an issue about the lawfulness.
But by paragraph 30 of the witness statement, the witness is trying to raise issue with CI 127.
No, my lord, the petitioner is raising an issue over the fact that the first respondent, without good reason, interposed that regional collation center. My lord,
you see, that were the provisions in CI 120. That was the regulations that regulated or governed the elections, the conduct of the elections. And if you did not raise any issue with it, that the first respondent did violate CI 127, and in your evidence you try to raise issue with how, for the first time, how there have been changes, now strong room to constituency collation. That's what CI 127 said the election should be conducted. So, and you never raise any issue with it. Then in your evidence, you try to raise issue indirectly.
My lords, with the greatest respect, I believe that we are confusing an issue about whether we are seeking to challenge or raise an issue with CI 127. And we're saying that that is not the objective. But CI 127 has to be executed. And if the petitioner, in making this interposition without good reason, if the petitioner has, as a result, had problems in the collation, which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outline in their answer. My lords, I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from paragraph 5.
No, Mr. Tsikata, we don't want you
so
to read that one. We are familiar with that.
So, my lords, if I could, in oral testimony, leading him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent, which says they went in accordance with this and this and this and that? My lord, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of votes and so on. There are pleadings made in relation to that with exhibits provided. And my lords, I do want to insist, and your lordships can correct me, if he were being led in the witness box in oral evidence, would I not be able to put the case of the first respondent to him? I could.
You could, but the way you have framed the evidence in paragraph 30, whom are you blaming? Mr. Tsikata, look at paragraph 30 carefully. Whom are you blaming?
Whom am I blaming?
Yes, this evidence.
Blaming?
Yeah, blame, B-L-A-M-E. Blame.
My lord,
is it Parliament or the first respondent or the structure that was
my lord, frankly, Parliament has nothing to do with this.
Yeah, because what he did...
Parliament has nothing to do with it, because this is subsidiary legislation.
It was laid before Parliament.
Yes, but I mean,
it was laid before Parliament for 21 days.
My lords, anyway, my lords, I believe that is really not the essence of, because it
totally is. It's the essence.
So is Parliament responsible for all subsidiary legislation laid before them?
The testimony.
Please.
The testimony, as far as I understand it, you are blaming CI 127 on her, because you are saying that out of 127, CI 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
No, we're saying that the implementation of the law is what occasioned the problems. And that this interposition without good reason was the opportunity for that really error-ridden implementation to take place. That is what we're saying.
But the problem is with the implementation of the law. Then, in essence, the first defendant, the first respondent, did violate the law. But you've not indicated anywhere.
Necessarily, you don't have to violate a law in order to implement it in a way that occasions...
If you don't implement it correctly, as provided in the law, then you have violated it.
Well, my lords, we are saying that there was a lack of due process. There was a lack of due process in the implementation. The lack of due process is certainly an aspect of the implementation of the law. It does not require us to challenge the law or to say that the law itself is the problem. We're saying that in the implementation of a law or of a statute, a piece of subsidiary legislation that she introduced without good reason, we're saying that that was a part of the problem. And we've given a sample of why that occasioned the problem. In paragraph 32, indeed, aggregating the votes, yes, my lords, aggregating the total valid votes as shown by the 275 submission released by the first respondent on his website The resultant figure is actually 13,200, which is different from the 9. I mean, my lords, how can there be an objection to that passage of evidence? That is a passage of evidence in which reference is being made to the website of the first respondent in order to address figures that she herself, or figures that her first respondent has put forward as a correction of other figures that she read, which we all heard. She's put forward those figures. And here, and then subsequent to that, there is published on the website, 275 constituencies. And we do our arithmetic and we say that those figures actually result in this, not in the figure of the purported correction. How could that possibly not be, you know, I mean, a piece of material evidence from a witness in this election petition, aggregating the total figures? And my lords, this comes directly following paragraph 31 after the 7th December 2020 presidential election. Petitioners, paragraph 31 of the witness statement, petitioners' representatives in the strong room discovered that there were errors as a result of which they did not certify the summary of the results from some of the regions. They also noticed anomalies with some of the collation sheets that may have been inputted into the results. Based on the observations, the NDC calls a letter and so on. And then indeed, and it follows by talking about what what the first respondent put on the website, which is in contradiction to what she purported to be the correct figures. I mean, my lords, and what is more, those figures are different from
they are not making any case against paragraph 31. Yeah.
Yes, but paragraph
32.
Paragraph 32.
They are not quarreling with
paragraph 32 is stating quite clearly that the figures that were published by the first respondent on their website, when you put them together, and this again is a matter relevant to the different figures that were being offered by way of correction on the 10th and later. So I think this is a very material, you know, every piece of evidence, especially, my lords, when it is acknowledged that the witness can have put to him the case of the first respondent. The case of the first respondent is that an inadvertent error was made and it was corrected. And the correction itself was subsequently corrected. And we're saying that when you take what is on their own website, this is effectively in the nature of an admission by them that they were wrong even in their purported correction. This is a clearly material piece of evidence. And in paragraph 33, which is the last, I think the last but one, again, this is a statement of that point, that the aggregated figures, the aggregated figure from the total valid votes as shown by the 275 summary sheets released by first respondent on his website, this figure is also different from the corrected figure of 10th December in the unsigned press release. So paragraph 32 makes reference to the figures on the website, and then paragraph 33 says that that was also different from the corrected figures. And my lords, with the greatest respect, the issue that is at stake in this petition is the conduct of the first respondent as the returning officer of the presidential election. And that conduct...
Mr. Tsikata, which relief relates to the conduct? If we look, which relief? For settlement. You're seeking declaration.
The issue that we've put down, the relief that we have put down is a relief. We have put down a number of reliefs. Now, relief A is that the chairperson was in breach of Article 63(2). Relief B, a declaration are based on the data in the declaration made, the data contained in the declaration made by Mrs. Jean Adukwei-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7 December. No candidate satisfies the requirement of Article 63. The third relief is a declaration that the purported declaration made on 9th December of the results of the presidential election by Mrs. Jean Adukwei-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7th December is unconstitutional, null and void, and of no effect whatsoever. Now, I mean, we have set out in the preceding pleadings the basis of our claim of unconstitutionality. We've set them out, including the failures in respect of Article 23 and the failures in respect of Article 296. We've set them out. And we're saying that
thank you.
A declaration that is unconstitutional should be made. And in paragraphs 32 to 33 of the witness statement, we are responding as we're entitled to we're responding to the case that the first respondent is putting forward, in which she puts forward certain numbers, and we are relating those numbers to what she herself had, or what the first respondent had put on their website. And with the greatest respect, that is clearly a relevant matter. Now, my lords, I have to say that, I mean, these attempts to, take out of our witness statement extremely material matters that relate to the case that is being presented by the first respondent, I mean, are really matters that we consider, really very, very seriously, because we cannot see how anyone can objectively claim that these changing figures that we have been talking about as part of the lack of transparency and so on cannot be accepted as part of the witness's witness. Paragraph 37, this conduct of certain officials, and maybe, again, my lords, paragraph 37 cannot be read in isolation of the previous paragraph, because when it says this conduct, the meaning of this conduct cannot be read without going back to 36. In 36, because 36 says, Exhibit F is a spreadsheet covering sample details from 26 constituencies showing vote padding by certain officials of first respondent in favor of second respondent. When the votes second respondent obtained in all polling stations are shown on their respective pink sheets in these 26 constituencies are aggregated, the resultant figure differs from the figure that was declared by first respondent for second respondent as captured on the summary sheets of the respective constituencies. They show that more votes were added to those of second respondent than he had in fact obtained. So this is a conduct that is then referred to at the beginning of 37. This conduct of certain officials of first respondent in padding the votes of first respondent is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of first respondent to have second respondent unconstitutionally and unlawfully installed as president of Ghana. So this again is evidence that concludes paragraph 36, and paragraph 36 is not being objected to, and it concludes paragraph 36 and indicates that this conduct that is referred to is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers. And my lords, whether indeed numbers were being manufactured or not is obviously a question of fact. It's an issue that is to be resolved by the evidence of the parties and by the determination of which evidence is worthy of acceptance as truthful evidence. And therefore we submit that none of these passages of evidence can be considered as passages that cannot be legitimately within the witness statement of our witness.
With the leave of your lordships, we wish to refer to Order 11 to reply. Yes. Yeah. May I have the lead of the court to reply? My lords, I wish to refer to Order 11, Rule 12.1 of CI 47, which reads, and I quote, subject to sub-rule 2, every pleading shall contain the necessary particulars of any claim, defense, or other matter pleaded, including, but without prejudice to the generality of the foregoing words. A, particulars of any misrepresentation, fraud, breach of trust, willful default, or undue influence on which the party pleading relies. And B, where a party pleading alleges any condition of the mind of any person, whether of any disorder or disability of mind, or malice, or any malice, fraudulent intention, or other condition of the mind, and except knowledge of particulars of fact on which the party relies. My Lord.
Mr. Akoto Ampaw, what you've just read is for the practice and procedure in the High Court.
Yes.
Yes, and that's not what is before us is not pleadings properly so-called. This is an election petition.
Yes.
And it's regulated by the rules and other things. So we have made it clear that we are not applying the High Court Civil Procedure rules in this case. We are applying the Evidence Act to regulate the taking and admissibility of evidence in this case. So allow us to regulate the procedure, because this is an election petition, because it appears it's something new. So the lawyers keep on referring us to the High Court Civil Procedure rules and other things. But this is a peculiar jurisdiction which we are exercising.
My Lord, my understanding is that these rules may provide guidance to the court, and it is part of our legal practice where a party alleges matters relating to a state of mind, like predetermined mind and prejudice and so on. He must give particulars in his petition. The petitioner never gave the particulars relating to the alleged predetermined intention, the bias, and so on. None of these matters, particulars, have been pleaded. And we would urge, based on that and all the other things we have submitted to this honorable court, that the pleadings, the evidence, the paragraphs in the evidence, many of which are actually material facts which ought to have been pleaded, should not be admitted. We pray accordingly.
Respectfully seek your permission, because a point of law, a new point of law has been raised. Because as that very well.
Yeah.
All rise.
You're watching our coverage of this 2020 election petition. It's day one of trial, but what we've witnessed really doesn't look like that of a trial. We'll take you through what's been happening. So this hearing started at exactly 10 a.m. First witness called Johnson Asiedu Nketia, General Secretary of the NDC, but in his capacity as a witness for the petitioner. There was an objection raised, and that's what's been debated, dealt with for more than 2 hours now, a little over 2 hours. Mr. Akoto Ampaw, lawyer for the second respondent, Nana Akufo-Addo, raised objections on 3 grounds, about 10 paragraphs, some of which he wants entirely struck out. Others, he says the court should not entertain it. So the 3 grounds based upon which he's raised these objections are: 1, that some of the facts contained in the about 10 paragraphs were not pleaded, and then also the second grounds for the objection is the fact that they are prejudicial, and then the third one is that they're scandalous. About 10 paragraphs containing that witness statement that he's objected to, and we've seen lawyer for John Mahama, Mr. Tsatsu, also making the arguments why those statements should be maintained. So we've seen that for about 2 hours. We've been watching and listening to that back and forth. The Electoral Commission lawyer simply just agreed with the points raised by Mr. Akoto Ampaw. So just agreeing with him, but the fact that these 10 paragraphs should be struck out is what the court has been dealing with all morning into the afternoon. My name is Mama Viosa Wajikojansing. My colleague is here. We will be talking to our court correspondent, Joseph Akable, who is on the ground. But our election petition update is brought to you in association with Petrosol, DBS Roofing, and Co-op Mixture. We will be back in a little bit. Stay with us.
Joy Learning is 1 year old. Hooray! This year, there's so much to write about in the Joy Learning Essay Club on Facebook. And we start the year with the anniversary edition of the Essay Club in 300 words. Write on the topic how Joy Learning can be helpful to students as schools reopen. Your essays must have your full name, your age, a contact number, and your school's name. Send a scanned copy of your essays as a direct message to our Facebook handle at Joy Learning TV. The best 10 essays qualified to be part of the finalists of this educative contest. And there are many Joy Learning at Once souvenirs to be won, not forgetting the opportunity to become a Joy Learning ambassador for 2021. Remember, the topic is how Joy Learning can be helpful to students as schools reopen. The deadline for submission is 5th February 2021. Joy Learning at One, celebrating a year of impactful television teaching and learning. Joy Learning, keep learning.
In Ghana, the law enjoins all drivers and passengers in a moving vehicle to wear a seatbelt. No excuse is good enough for not wearing a seatbelt. Seatbelts that are fitted in vehicles are adjustable, so please adjust it to suit you. Let it rest as close as possible to the body. As a driver, before you drive off, ensure everyone else, especially children in the vehicle, have fastened their seatbelts. The airbag is not an alternative to a seatbelt, because in the event of a crash, only the fastened seatbelt will stop a passenger from being thrown far forward. So buckle up. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
My beautiful wife is about to make some sweet jollof, and she uses only Lavon's tomato mix. Oh, look at that thick red paste. Quality papa. Lavon's is what makes her jollof so delicious.
This is not just jollof. This is love.
Lavon's tomato mix. Love day inside.
This advertisement has been vetted and approved.
It's time to go digital. Create your unique online store in a few clicks. Connect your Facebook shop, Instagram, or WhatsApp business and add your products, prices, images, and stock levels. Collect payment online, offline, and in your shop. Get instant notifications of your orders and payments and deliver your product to your customer's doorstep with our delivery service. Manage your sales, customers, and staff from anywhere at any time. Get our Digipack and up to 200,000 CDs working capital to grow your business. Visit digistoreafrica.com and set up your business for free. Digistore, powered by iPay and EcoBank. It's time to go digital. Create your unique online store in a few clicks. Connect your Facebook shop, Instagram, or WhatsApp business and add your products, prices, images, and stock levels. Collect payment online, offline, and in your shop. Get instant notifications of your orders and payments and deliver your product to your customer's doorstep with our delivery service. Manage your sales, customers, and staff from anywhere at any time. Get our Digipack and up to 200,000 CDs working capital to grow your business. Visit digistoreafrica.com and set up your business for free. Digistore, powered by iPay and EcoBank.
It is the first day of trial in a case where the NDC's presidential candidate in the 2020, John Dramani Mahama, is challenging the declaration of President Akufo-Addo.
Because the figures are coming out of nowhere and without reference to anything that is transparently communicated to anybody. My Lord, with the greatest respect, I find it very difficult to see how any objective observer of the ever-changing figures that have been put forward can fail to see that we are not justified in talking about figures being cooked. And my Lord, figures being cooked is simply an indication that the figures are, just being thrown up, unrelated to valid votes being cast, counted, and collated, which is what it should be. So, my Lord, respectfully, we would submit that there is a basis in our pleadings about lack of transparency, lack of due process, in respect of paragraph 30, and if your lordships could again perhaps read out what the ground, the specific ground is, so that...
Asking for help with paragraph 30.
Yes.
30, the whole of the paragraph.
Yeah.
On the basis that...
Yeah.
On the basis that the witness cannot speak to the legal validity of the legislation referred to, that is CI
127. Mm-hmm.
Okay, my lords, this again is not a pleading of law at all. This pleading states in the new regulations promulgated, and it's not an issue about the validity of the constitutional instrument. That is not the issue. In the new regulations, this is just a factual statement about how the new regulations operated. In the new regulations promulgated by first respondent, CI 127, it now interposed between the strong room and the constituency collation centers, without any good reason, another layer of collation at its regional offices with regional summary sheets. That is a fact. It did that as a result of the constitutional instrument. This led to results being sent from regional collation centers which were at variance with the results collated at constituency collation centers as a result of figures being altered by officials of first respondent. Exhibit C provides sample details of wrong aggregation of valid votes on the face of the summary sheets of some 11 constituencies. The exhibit shows that the sum total of votes, of valid votes obtained by all candidates varies from the figure recorded on the face of the summary sheets as the total valid votes from each of these constituencies. Now, my lords, the statement there is quite clear about the interposition of the regional collation centers as a source of errors. And an exhibit, Exhibit C, is also provided in the petition with the sample details. Now, my lords, it needs to be clear. It needs to be clear that in this petition, unlike perhaps in the 2012-2013 petition. The petitioner did not come to court saying that now 4 million votes of voters who have voted annul them because in some cases pink sheets didn't have presiding officer signature or there were duplicate serial numbers. That, in the nature of this petition, the petitioner is saying that a certain declaration was made on the 9th of December. It was publicly made, we all heard it, and the petitioner is saying that when you look at figures in that declaration itself, those figures do not amount to compliance with a constitutional provision duly. That's what now, in this paragraph 30, what the petitioner is seeking to do is precisely to provide, as it is said, a sample of wrong aggregation, and the petitioner is attributing that to the interposition of the regional collation center. So that is the import of that paragraph, and that import is related to the lack of transparency pleadings that we clearly have.
Mr. Tsikata,
yes.
Your pleading indicates that that interposition comes from the new regulation, from the law. Isn't that your pleading?
The new regulation is, I didn't hear the last bit of
the testimony of the witness is that the interposition, the
new regulation
interposed, yes.
Yes.
And that's the source of the trouble. That's the source of the complaint.
Yes, in its operation, the way it operated, the way this new regulation was operated in practice.
And the objection is that it seems to suggest that the new regulation of first respondent was about ensuring that the process of collation and aggregation of votes were introduced without good reason. And yet that was introduced through a law. It was a law that provided that framework. And
yes,
that is a complaint.
It was subsidiary legislation made by the first respondent, and the witness statement is indicating that the operation of that, it was a matter of law, but you can operate a legal provision in a manner that leads to wrong results. That's what we're saying. I mean, you could operate the creation of regional centers in a transparent way, which does not lead to the results.
And so, once again, you are inviting us to make an inference, or what?
My lords, I'm not inviting just making an inference. I'm saying that we have pleaded a lack of transparency. We have pleaded a lack of consultation in respect of how these figures popped up. And the witness statement is showing one of the ways in which that lack of transparency was demonstrated in the actual conduct of the first respondent. That is what the witness statement is seeking to do as a matter of evidence.
But Mr. Tsikata, there is nothing in the petition about this, let me call them collation issues. There's nothing in the petition that the collation process resulted in changed figures or figures changing.
We have pleaded the fact that numbers were being changed by the first respondent without any transparency.
No,
now,
this is such a big issue that if that is your case, it should be in the petition that A, B, C, D, from this polling station to this constituency to this regional collation center, these figures changed. There's nothing about this in the petition.
My lords, the petitioner is not the returning officer for the presidential election.
Oh, but he's the one challenging
the petitioner. May I answer you? The petitioner is challenging, firstly, on the basis that you made a declaration in which you put forward certain numbers. On the face of your declaration, those numbers do not warrant your exercising your constitutional responsibility the way you did. That is the basic point of the petition. My lords, if I may finish my answer, because I believe it's important for the answer in its fullness to be heard. That the petitioner makes clear that her challenge is based on the fact that the person who is a returning officer, that person has purportedly made a certain declaration of someone as having won the election. And yet the figures that she has put in as the basis of her declaration, those figures do not warrant her declaration. That is the heart of this matter. Now, my lords, at the heart of that petition is this issue about the numbers that were acted upon by the first respondent. First respondent puts forward an answer in which effectively first respondent says, I am actually admitting that there were errors. That's what first respondent is saying. First respondent is saying, I'm admitting there were errors, but one, they were inadvertent. And they were corrected by a press release on the 10th of December 2020. We point out that the so-called correction itself contained mistaken figures. We point that out very clearly. And we further point out that those figures kept changing right up until the point where we have in the witness
My lords,
statement.
with respect, Council has been repeating the same things for the past 15 or 20 minutes. It's the same thing he's been repeating.
My lords, I don't know whether that's meant to throw me off the course of my argument, but I think with respect, this is intolerable with respect, because I was in the middle of a sentence actually, and you know, it is not appropriate, you know, to make this kind of interjection.
Yeah, please, when you want to raise an objection, it has to be timeously raised. Yeah, so that, yes, you don't disrupt.
My lord, I thought I was actually raising it timelessly.
My lords, I believe I was in the process of explaining that at the heart of the petitioner's petition before this court is a challenge to the declaration. And it's not just a challenge about figures, but it's a challenge related to the constitutional consequence arising from those figures. And we're saying that after, we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you're supposed to be speaking to paragraph 30. which is about the collation. And the question from my brother on my right was that there is nothing in your pleadings about the collation process.
My Lord, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. So the witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through, these 4 stages, and so she is in effect explaining herself in terms of her conduct, and we are saying that on that basis, the witness is entitled, because, my Lord, if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead him and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? My Lord, that's perfectly legitimate if I were leading him in the normal course.
Counsel, in fact, with the greatest respect, my problem is this. In the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127, the law that regulated election.
And the petitioner does not seek to raise an issue about the lawfulness
But by paragraph 30 of the witness statement, the witness is trying to raise issue with CI 127.
No, my Lord, the petitioner is raising an issue over the fact that the first respondent, without good reason, interposed that regional collation center. My Lord,
you see, that were the provisions in CI 120. That was the regulations that regulated or governed the elections, the conduct of the elections. And if you did not raise any issue with it, that the first respondent did violate CI 127, and in your evidence you try to raise issue with how, for the first time, how there have been changes in now strong room to constituency collation. That's what CI 127 said the election should be conducted. So, and you never raise any issue with it. Then in your evidence, you try to raise issue indirectly.
My lords, with the greatest respect, I believe that we are confusing an issue about whether we are seeking to challenge or raise an issue with CI 127. And we're saying that that is not the objective. But CI 127 has to be executed. And if the petitioner, in making this interposition without good reason, if the petitioner has, as a result, had problems in the collation, which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outlined in their answer. My lords, I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from paragraph 5.
No, Mr. Tsikata, we don't want you to read that one. We are familiar with that.
So, my lords, if I could, in oral testimony, leading him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent, which says they went in accordance with this and this and this and that? My Lord, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of vote.
In this case, former President Mahama and his lawyer.
And in an error-driven declaration, and shows, and my Lord, that's a critical passage, shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast in the presidential election.
So does your objection start from the CPC or start from simply being?
No, it starts from shows, but you can only understand the shows if you relate to it to what comes before. But the specific objection relates to the showing that the figures were simply being cooked. My lords, we say that this portion of paragraph 28 is extremely prejudicial. No facts have been pleaded to that effect and ought to be struck out accordingly. My Lord, paragraph 30 of the witness statement. My Lord strangely seeks to suggest that the first respondent, because of his bias in favor of the second respondent, somehow.
Could you tell us what you're objecting to? The
whole of the whole of it. Yes, the whole of paragraph 30. My Lord, it seeks to suggest that the new regulations were organized by the first respondent with the object of ensuring that the process of collation and aggregation of votes were introduced without any good reason. My Lord is talking about a piece of legislation. My Lord, it is the witness may not speak to the legal validity of a piece of...
Mr. Ampaw, so is it your objection that it's not based on pleadings, or that it unduly prejudices, or it's scandalous? You've told
My Lord,
us
it's
three
not
grounds.
based on the pleadings, nor is it, and furthermore, it is unduly scandalous. And my Lord, our next objection No, I don't. The next objection, my lords, relates to paragraph 32. My lords, this was not pleaded by the respondents, the petitioner, and my lord, it relates to 275 summary sheets results. My lord, nowhere in the petition has there been any reference to any 275 summary sheets. And the petitioner had all the opportunity to do so if he intended to rely on this evidence. In the trial. He failed to do so and is seeking, through his witness statement, to improperly introduce it through the back door. Should be, and we pray, therefore, that it be struck out. My lords, indeed, if your lordships take a look at the petitioner's amended petition, even exhibits were attached to the petition when they should not have been. And so they had every opportunity, even at the time of filing their petition, to follow that flawed tradition, but they didn't. And now, when they asked to write their witness statement, they introduced this huge piece of evidence which they hadn't pleaded. We ask that it be struck out as not based on the pleadings. And consequently, paragraph 33, which is a consequence of paragraph 32, should also, in similar fashion, be struck out. Yeah. I hear you. My lords, as we've indicated, it is well established that a party's pleadings are fundamental in determining the case he or she intends to make during trial. A party's pleadings also notify the other side of the case that he will meet in court. My lords, the significance of pleadings have been set out very clearly in the case of Hammond and Odoi, 1982-83, 2 Ghana Law Report 215 at 1215 at 1235 to 1236. My lords, I know that this statement of the law is very well known to your lordships, so I will not detain you with reading it. My lords, I wish further to refer your lordships to the case of Adejumo versus Abegunde and another, reported in 1965 Ghana Law Reports 499, 1965, my lords, Ghana Law Reports.
Upon a scrutiny of the petition, we found that the issues to be determined are set out at page 125 of the Council for Petitioners' written address. They are as follows: 1. Overvoting. 2. Voting without biometric verification. 3. Absence of the signature of a presiding officer. 4. Duplicate serial numbers. That is to say, occurrence of the same serial number on pin sheets for 2 different polling stations. 5. Duplicate polling station codes. That is to say, occurrence of different results or pin sheets for polling stations with the same polling station codes. And 6. Unknown polling stations. That is to say, results recorded for polling stations which are not part of the list of 26,002 polling stations provided by the second respondent for the election. We unanimously dismiss the claims relating to duplicate serial numbers, duplicate polling station codes, and unknown polling stations, as for short. Atuguba, Adeyira, Bafubani, Gwedegwe, and Akoto Bamfu JJSC dismissed the claim of overvoting. Atuguba, Adeyira, Bafubani, Gwedegwe, and Akoto Bamfu JJSC dismissed the claim relating to absence of signature of presiding officer. Atuguba, Adeyira, Doche, Bafubani, Gwedegwe, and Akoto Bamfu dismissed the claim relating to voting without biometric verification. Ansa, Owusu, and Eni Yabua JJSC grant all the 3 claims, that's to say overvoting, absence of presiding officer signature, and voting without biometric verification, and all the votes involved, and order a rerun of the affected areas. Doche JSC grants the claim of overvoting, but has provided a roadmap in his judgment as to the figures of votes to be ascertained and cancelled, and a rerun of the areas affected.
Welcome to another episode of Meet the Leader, brought to you by the Uongozi Institute. I am your host, Akufo-Addo. On this program, we're extremely honored and privileged to have His Excellency Jerry Rawlings join us to share his views on leadership and some of the lessons he's learned along his leadership journey. Your Excellency, welcome to the program.
Thank you.
Now, you're a very storied and well-known head of state from Africa, and you've done a lot for both Ghana and for the continent. And we'll get to some of that later on, but I want to start right from the beginning. As you reflect on your leadership journey, where did that start and how?
I was pretty young, around the age of 9, I think, 8 or 9, as I sat in a compound one day, and my auntie was whispering mother, my grandmother, that she would have to secure a party card before her husband would be paid. Her husband happened to be an Englishman who was building a lot of the estates in a new township. I mean, that she had to secure a party card before she can be paid, before they can be paid for the work they've done. Didn't make sense to me at that age. Plus the fact that she was whispering. You only whisper when you're afraid of your environment, correct? And plus a few other things, you know, in the climate, in the atmosphere. The young pioneers. Well, not too long, yeah, we had, no. This was after the age of 10, I think. We had won our independence. I mean, Nkrumah was the leader then. And I have to admit that as the years went by, people became more and more frightened of his government, his party machinery, you know. I mean, he no doubt meant well, you see what I mean, for his race, for Africa. But I don't think his party machinery or people around him became intoxicated. And it ended up creating a lot of stress over the years. I mean, his overthrow came as no surprise to me at all. Even at around the age of 15, when I was in school, secondary school, boarding school, one of the minister's children dropped a cake of soap, brand new, as he removed the cover. And it was a fairly clean bathroom, a common communal bathroom. He refused to pick up the soap. Yes, he went to look for a new cake of the Lux soap or whatever. And all kinds of things. You know, you had situations where we respect and admire our teachers. When you end up with a situation where teachers that you admire are afraid of students because of who their parents are, does not go well for the political climate at all. So it created a lot of animosity against Nkrumah's government.
Okay. No. And for you, on a kind of personal, familial note, was there anything in particular about your household or the culture that you were raised in that made you kind of sensitive to, you know, a sense of injustice and that kind of responsibility and equality that clearly seems to be coming through? Was there anything in particular that?
Yeah. I can cite you another example. When I left school and joined the military academy into flying, the Air Force, after about 3 months of hard training, we were all invited individually and interviewed. And I remember there were these two white guys. The question they were asking me was if I could see myself someday enjoying a drink with my colleagues, fellow cadets. I think I understood what they were saying, but I pretended I didn't. So they asked it again and again. The third time I said, I think I know why they're asking me this question, because they find me snobbish. I snub my colleagues. Yes, I do. And that's because where we live, the quarters, the military quarters, every room has been assigned, a batman, like a manservant. And I don't like the way they treat them. My colleagues treat those manservants. And when I look at them, it doesn't appear as if any of them grew up in homes where they had house helps or servants anyway, you know. And to come here and have this privilege and be treating people this way is something, yes, I don't like. And that's why I snub them. But the reason is that I grew up in homes where there were servants. But the point is, you have your responsibility. You do your sweeping, you lay your own bed, etc. And the servant has his or her responsibility. So in effect, you end up growing up respecting each other and appreciating and behaving like brothers and sisters. Do you understand? Yeah. And in the process of growing up too, I worked with laborers during holiday vacations, etc. And I've grown up with people. I did not grow up and allow anything to take me outside the orbit of reasoning, you know, the empathy that we must necessarily have for one another. So.
No, it's interesting you say this because, of course, you had a storied career with the military, which we'll come to. But you know, the military is known for breeding leadership. I mean, it's a core part of how leadership or how military training progresses. So in your case, actually, the leadership responsibility was framed outside that. Did you find it difficult to reconcile this with the kind of military regiment, or were the two quite
No. We got along. Okay. I mean, when I was at school also, you know, that boarding school I just talked about, I joined the Cadet Corps, you know, and I'd always wanted to fly anyway, and I'd always wanted to join the Air Force, you know. So for me, the military was next to nature, really.
Sure. Mm-hmm. And it seems you were very popular in the military, at least amongst your peers, from looking from it from the outside. In 1979, you led an unsuccessful coup, and you were actually arrested and sentenced to death. And then a month later, there was a successful coup, and the military kind of rescued you, and then progressed to move you to lead the kind of transition government. What was it that you think your peers saw in you as a leader?
That is part of the disinformation, because people do not want to, or the media, or those who are opposed to the concept of the fact that humanity has a right to revolt. You will find it in the ethics of man. I don't have to go into that book to prove my point. Mm-hmm. But they must necessarily call it a coup all the time. 15th May, the atmosphere was so charged. It was pretty much like what I keep calling, opening the gas in a kitchen and the place is filled up. All you need is just to ignite a match and throw it in.
So something was...
It would blow up. I mean, nobody could have carried out a coup d'etat in those days, because the command structure had so much lost, respect, you know, from the bottom all the way up.
Kind of legitimacy.
That's correct. It would have been difficult for any officer to undertake a coup. The atmosphere was just ripe for an explosion. My concern was that if we didn't hurry up as young officers to attempt to rescue it, to arrest the situation, ahead of 79, the extent of rage would not have reached that depth or that height, but we waited too long. And that's why the atmosphere, not just in the military, the whole nation was calling for blood, blood, blood. So you've got to understand that 15 May, I was full of rage too. Yes. And all I had to do is to ignite it. I didn't need a whole battalion. 10, 12 people is all I had. And we were in a position to do so. But at the last minute, I decided no, I couldn't. Because so many innocents would be killed. Yes, officers, their wives and children, etc. The extent of rage amongst the rank and file was too much. So I decided no, I wasn't going to ignite it anymore. And I asked my boys to go to have some rest, because we were as ready as midnight. Incidentally, the night is a more secure and safer time for people who want to do violence. Yes. The daylight has a restraining effect, naturally. So I thought I'd ask them to get some rest and would start around 3 o'clock in the morning. I changed my mind without letting them know that I changed the plan, was to arrest the armored squadron, the armored vehicles, and demand for a confrontation with the generals. You know, that a change must take place. Something has to happen. So that would use dialogue to make the change. And of course, I knew the new change, the new plan was kind of risky. And that's what happened. Now, the very thing I was trying to prevent, this explosion, through the action of, incidentally, something I said during the trial was that leave my men alone. I'm prepared to take responsibility for all that's happened. I think it just caught on like wildfire, like they couldn't believe that an officer would want to sacrifice his life for them, etc., etc. So one thing led to another, and some general actually signed for my execution, on that Monday. And of course, they typed it, the word had gotten around. And the very explosion I was trying to prevent. In other words, that was also not a coup d'etat. It happened, the spontaneous thing. There's a fellow officer, I don't even know, who went around 3 o'clock in the morning calling out, like, where are they, etc. And couldn't see people come out and shot himself. And I think that is what ignited it, etc. It's a long story. Got into, so I was released, went to the broadcasting house, made the announcement that I needed to do, sort of inviting fellow officers not to stand in the way of the ranks, because they're full of venom. And when I say they're full of venom, let me take you through one or two examples. Under the Achampong regime, the general's regime, the economic situation had become so bad that antibiotics, baby milk, was being sold in markets on tabletops. Yes. And scooping, correct.
So you really had the tough.
That's how bad it was, that hoarding. These Makola market women would go into the shops, the major shops, and purchase all the cloth, everything, etc. Baby milk, name it. Even antibiotics was being sold on tabletops like you have in a market. So you have a situation like that where soldiers, not once, not twice, not 3 times, would go pleading for a reduction in the price. There was also an escalation of price. And the country had grown to hate us, hate the government, And a poor soldier in uniform, like I said 3 times, goes to a market to ask for a reduction in the price of cloth for his family. And what do the market women do? They throw urine at him. Yeah. Urine at a soldier in uniform?
But any human
I'm not saying correct. Taboo. I mean, that's the contempt that they had for the uniform in those days. So at that moment, you can understand how much he would hate that woman, hate his general up there. No, the officer corps, and we were seen as officers. They didn't see that, there are officers and there are officers, generals and whatnot. Oh yeah, they would have done us all in,
So you've really been driven by a sense of fairness and justice, but also a loyalty then to the state, as it were, the state of Ghana, stabilizing it and so on. You very quickly ceded from the military to a civilian role, and that was short-lived. And so you were brought back in and managed to stabilize the country by establishing the Fourth Republic.
I wasn't brought back in.
Oh.
I came back in.
Okay, sure.
When we handed over the first time to Liman, after 3 months, it was almost as if, 8 generals, including 2 former heads of state, had been executed. And some of them were innocent people, commanders. But it was best to sacrifice the commanders than to go down the ladder of all the guilty people that the rank and file knew about. It was a very difficult thing. At first we thought we could sacrifice only 2. 10 days later, the tension was building up. If we didn't let go, they would start collecting. Meanwhile, they had arrested officers in all the units, except for, those within the rank structure that I had named. So, etc., etc. That period was an expression of rage But thankfully, we managed to contain it within the military, and we paid the price for it, the national prize. And then the handover comes, very swift. You think all that anger and all that rage has dissipated? Of course not.
Take some time.
It'll take time, etc. You know, etc. But to cut a long story short, there was still a good store of it, with a hope that in giving the power to this new administration, the road, you know, of integrity that we had embarked on, the sense of justice, fairness, would be continued, would be an underlying principle. But no, the nonsense did not only start, the state security machinery started arresting and persecuting.
To paragraph 26, which the second responded in raising an objection to this, said that it is scandalous. And he said it's scandalous based on what is written. There's a chairperson of the first respondent and the second also not required under Article 296 of the Constitution to be quote, biased, either by resentment, prejudice, or personal dislike, unquote, in exercising any discretionary power, but they are required to exercise such powers, quote, in accordance with due process of law, unquote. The chairperson of the first respondent, Mrs. Jane Addo allowed herself to be biased by a prejudice in favor of second respondent who appointed her in August 2018 and with whose wife, Mrs. Jane Addo has a close familiar relationship. Mrs. Mensah was thus at all material times in the conduct of her responsibilities biased by prejudice in favor of the second respondent and against the petitioner. And again, the second respondent had issues with this bit of it, and they describe it as being very scandalous and prejudiced. Then we move to paragraph 28. Paragraph 28, another objection raised on paragraph 28. And on paragraph 28, they had issues with this part of the paragraph where it reads that secrecy and lack of transparency regarding the figures thrown up by one or more officials of the first respondent seeking to justify after the event. Mrs. Jane Addo-Mensah's 9th December 2020 purported declaration undermines the whole attempt at, quote, correction, unquote, of what was indicated an error reading declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual votes cast in the presidential election for the various candidates. That's just a paragraph 28. They raise other issues concerning paragraph 30, 32, 33, and 37. We'll quickly take you back to the Supreme Court. The justices are about taking their seat for the ruling. Stay with us. We'll be right back.
The first and second respondents have raised objections to parts of the witness statement of Mr. Johnson Ketia, who has been sworn in as PW1. The objections to those paragraphs, precisely paragraphs 21, 6, 7, 25, 26, 28, 30, and 32, 33, and 37. Both counsel based their objections to the paragraphs in the witness statement of PW on two grounds. A, that some of the paragraphs under attack are not based on the pleadings on record. B, some of the statements are unduly scandalous and prejudicial. It would be preferable to set out the paragraphs in the witness statement which in our view are amenable to be struck out from the witness statement. We are of the opinion that paragraphs 6 and 7 ought to be struck out as the witness, Mr. Johnson Ketia, cannot testify on the facts in the said paragraph. It would have been admissible if the petitioner is himself testifying. The statements in the said paragraphs are not within the knowledge of the witness. We find paragraph 21 as a matter which has its foundation in the pleadings and same is accordingly maintained. As regards paragraph 25, we found that that is the sentence beginning with, quote, in fact, the ever-changing figures, end of quote, to the end of that paragraph is hereby struck out as not based on the pleadings. In respect of paragraph 26, the court is of the opinion that the statement from line 5 above, beginning with, quote, the chairperson of the first respondent, end of quote, to the end of the paragraph is struck out on the basis that it has no foundation in the pleadings. As regards paragraph 28, from line 6, that is the sentence beginning from, quote, the secrecy and the lack of transparency to the end, end of quote, to the end is not borne out of the pleadings, and we accordingly struck it out. In respect of paragraph 30, the court is of the view that it has no foundation in the pleadings, as it just refers to CI 127, which the witness cannot testify on the statute. As regards paragraph 32 and 33, we found that they are based on the pleadings and therefore ought to be part of the witness statement, and they are accordingly maintained. In respect of paragraph 37 of the witness statement, we found that it is just an inference to be drawn and not evidence. We therefore proceed to strike it out. The court therefore orders the paragraphs referred to as offending the law are hereby expunged from the witness statement of PWI.
And Lords, we are most grateful. We are most grateful to the court. As the court pleases, and just for the sake of clarity, I would like to understand what was said in respect of paragraph 30, paragraph 30, because the reference to the regulations in CI 127, that's in the first sentence, but the rest of the paragraph, including the exhibit C, is not related.
Yeah, the whole of paragraph 30.
The whole is
yeah, it's
the whole of
yes.
That's the whole of paragraph 30. For each polling station, 2 agents Now, at each polling station, the petitioner and indeed all the other candidates had agents. Is that correct? I cannot speak for candidates. Now, you trained your agents on what their duties at the polling stations will be.
Yes, my lord, that's correct.
You trained your agents on
Correct.
how from
Is that correct? That's correct, my lord.
You also trained them that if they stated the reasons for not signing, the issue will be taken up at the constituency coalition centers. Is that correct?
That's correct, my lord.
You also trained your agents that at the end of counting and entering of figures, they collect their copies of the Form 8, whether or not they signed it. Is that correct?
That's correct, my lord.
You also appointed agents for each of the 275 constituency coalition centers. Is that correct?
That's correct, my lord.
You trained them that unresolved issues from polling stations will be noted on Form 8B for resolution at the constituency coalition centers. Is that correct?
That's correct, my lord.
You also trained them to expect to receive the duplicates of the Form 8Bs that have been given to them at the polling stations. Is that correct?
That's correct, my lord.
Now, you also train them to cross-check their Form 8Bs with anything that is done at the constituency coalition center. Is that correct?
That's correct, my lord.
You also train them that from all the information on Form 8B, the EC officials will collate the results onto Form 9. Is that correct?
That's correct, my lord.
You train them that after collating on Form 9, the results will be entered on Form 10. Is that correct?
That's correct, my lord. But all with the involvement of our agents.
Now, you also train them that if they have any issues with Form 10, they could refuse to sign it and state the reasons therefore. Is that correct?
That's correct.
Now, you also train them that once the Form 10s were completed, they were entitled to their copies.
That's correct, my lord.
So it is right to assume that your agents had all the Form 10s with them. Is that correct?
Come again, my lord.
I'm saying that it is right to assume that based on your answers, your agents had the Form 10s with them.
Yes, my lord, it could be assumed.
Right.
Now, whether that is the case is another matter.
Now, you also agree with me that with our elections, results are declared at all the polling stations before they move on to the constituency. Once the results are counted, they are declared at the polling station before we move on to the constituency centers.
Yes, my lord, unless there is a challenge about a particular polling station results.
Yes. And at the constituency level, the collated results are put together, and then a winner of a particular constituency is declared. Is that correct?
We have two elections at the constituency that are collated at the constituency level. I don't know which one. Is that the presidential or parliamentary?
Sir, you are here because of the presidential election. Is that correct?
Okay, yeah.
My question is in reference to the presidential election.
The declaration is not done at the constituency level. They indicate the tally for each candidate. The presidential election results are declared at the national level by the returning officer.
Are you therefore saying that at the constituency level, your agents do not know who has this number of valid votes at the constituency level?
That's what I'm calling the tally. The tally of the votes are known, but that is not the declaration of the presidential election.
Okay, good. You trained your agents that the Form 10s will be transmitted to the regional coalition centers. Is that correct?
That's correct, my lord.
Now you also appointed agents to each regional coalition center. Is that correct?
That's correct, my lord.
Indeed, some of your agents, as announced publicly, were lawyers. Is that correct?
That's correct, my lord.
Now, you also trained your agents that all the information on Form 10s will be collated into Form 11. Is that correct?
That's correct, my lord.
You also trained them that from collating the results on Form 11, the results will be entered on Form 12. Is that correct?
That's correct, my lord.
Now, you also trained them that at that point, they would be invited to either sign onto the Form 12 or object. Is that correct?
That's correct, but they are involved, so they are not sitting somewhere only to be invited to sign. They are involved in the coalition, and if they agree that the process has been proper, they are invited to sign.
Okay. Now, are you aware that of the 16 regional coalition forms, your agents signed 13 of them?
Yes, my lord.
Are you also aware that one of such forms that was signed was in reference to the Ashanti region? Is that correct? One of the forms that your agent signed. It was in reference to the Ashanti region?
Yes, my lord.
Your agent signed the form for Ahafu. Is that correct?
That's correct, my lord.
Your agent signed the form for Oti. Is that correct?
That's correct, my lord.
Your agent signed the form for Northeast. Is that correct?
That's correct, my lord.
Your agent signed the form for Bono. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper West. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper East. Is that correct?
That's correct, my lord.
Your agent signed the form for Central Region. Is that correct?
That's correct, my lord.
Your agent signed the form for Western. Is that correct?
That's correct, my lord.
Your agent signed the form for Savannah. Is that correct?
That's correct, my lord.
Your agent signed the form for Volta. Is that correct?
That's correct, my lord.
And your agent signed the form for Bono East. Is that correct?
Bono
East.
Bono East.
It was signed by Ali Mohammed Samsudin.
That's correct, my lord.
Good. Now, on each of those forms, your agent signed to declare as follows. Quote, we the undersigned do hereby declare that the results shown above are true and accurate account of the ballots in the region. Is that correct?
That's correct.
Now, at the National Coalition Center, which is the headquarters of the first respondent, you appointed 2 persons to that place for the coalition. Is that correct?
That's correct.
One of such persons is Rojo
Metonunu. Is that correct?
Yes, my lord.
And Mr. Rojo Metonunu has been a former deputy minister before.
That's correct.
And Mr. Rojo Metonunu has been involved in elections and has even litigated 2 cases in these courts. Is that correct?
My lord, I can't testify to the fact about his litigations, but I know he has been involved in our elections.
Now, there's a reported case. Okay, right. Now, are you aware that at the National Coalition Center, Mr. Rojo Metonunu certified 12 of the 13 forms signed by your representatives?
My lord, I cannot testify or deny, but the other agent who will be present in court to testify as to what happened in the National Coalition Center, my lord.
Right. Now, let us go to your witness statement. You spoke about Exhibit D, the letter from the National Democratic Congress.
Yes, my lord.
Dated 9 December 2012. I suggest to you that that letter was not delivered to the first respondent.
My lord, our agent who was in the headquarters of the first respondent will be present in court and will attest to that fact.
So you do not know whether it was submitted or not?
A report was made back to me that it was submitted.
I am putting it to you that that letter was not submitted to the first respondent. Yes. I am putting it to you that that letter was not submitted to the first respondent.
My lord, that fact will be confirmed or denied by the agent who will be in the box subsequently.
So you are telling this court that you do not have personal knowledge of whether or not the letter was submitted to the first respondent?
My lord, I indicated that I had a report, a feedback that it had been submitted, and since I wasn't present there, I cannot say it as a matter of something that has come to my knowledge.
Right. Now, let's go to your letter. Your letter is in 2 parts. Is that correct? You can look at it.
You have it.
It is marked Exhibit D.
Yeah.
Would you be kind enough to tell the court the person who signed this letter?
My lord, it was signed by my deputy on my behalf.
What's the name of the person?
Peter Boama Otokuno.
Right. Now you agree with me that the portion marked C talks about parliamentary elections and therefore has nothing to do with the petition in this court.
Yes, my lord.
You also agree with me that Despite all that you've written about Ashanti, Ashanti was signed by a gentleman called Broja Jemfi. Do you know him?
Yes, my lord.
And I'm further putting it to you that Ashanti was signed by, was certified by Mr. Rojo Metonunu.
My lord, the agents who will come subsequently will be able to confirm that or deny it.
Do you know whether Rojo signed or not?
Please, I would like to take the question again.
I'm asking you whether you know that when Ashanti came in, duly signed by Mr. Broja Jemfi, Rojo Metonunu signed against it. Do you know or you don't know?
My lord, the documents that come to our notice is the final declarations, the signing on the regional declarations at the strong room are not brought to us.
Well, I'm putting it to you that for Ashanti, the form was signed by Broja Jemfi in Ashanti region, and when it was transmitted, and when it was transmitted to the strong room, as you call it, Mr. Rojo Metonunu signed it.
Well, I can't testify or deny because what happens in the strong room is within the knowledge of people who are in the strong room.
Now, you have attached to your letter 2 sheets from the Eastern region. Is that correct?
That's correct, my lord.
On the first sheet, your agent signed the form. Is that correct?
My lord, there are 2 sheets. I don't know which is first and which is second.
The second one is what you have. There's one that your agent did not sign. If you look at the forms, there's one. The one with the blue ink at the bottom, your agent did not sign.
Yes.
The one that doesn't have the blue ink, your agent signed.
Yes, my lord.
Right. Now, if you put together all the valid votes assigned to each of the candidates that your agent signed, the total will be 1,196,751, and not the 1,236,940 that was written on the form.
My lord, I have realized that the totals there are. Yes, I've looked at. Yes, my lord, that is precisely what I'm about to do. I have done the collations, the additions, and I've realized that the totals on both sheets are the same figures, but the figures that add up to the totals are different. And the one marked in blue is actually accurate.
No, we'll come to the one marked in blue. I am saying that if you add up all the valid votes assigned to all the candidates from number 1 to number 12 on the form that your agent signed, the total should be 1,196,751 and not the 1,236,940 that was written on it.
My lord, I can confirm that the totals are not the aggregates of the numbers there, but I don't remember the actual figure that I got. If the court will permit me, we can add and find out what it is. Yeah. But all our phones have been taken.
My Lord, my Lord, we brought the calculator.
Yes.
If the court will permit, you can do that.
Yes.
Order in court, please. Order.
1, 4, 6. Yes, your calculator is not 1, 2, 9.
It's order in court.
Lord, I have 1,196,751. Correct.
Now, kindly deduct that figure from the figure written on the form. That is 1,236,940. What will you arrive at?
$40,109.
A divine service.
40,000.
The aggregate has
109.
everything to do.
189.
189.
Okay, 189. Good. Now, look at the last page of your exhibit, which is the sheet that you attached to your evidence. Yeah, listening. Now, there is a constituency there called Ayenswano. Ayenswano. Do you see 40,189 over there?
Yes, my Lord.
I am suggesting to you that the second sheet that your agent did not sign was corrected to include the Ayinswanu constituency results.
Well, I cannot testify to that because if there is any correction to be made on any declaration, those who are part of the declaration must be present for the corrections to be made.
Yes, but you also are aware that where the person whom you have appointed to represent you leaves and refuses to be part of the process, those who are there sign onto the form and the process continues. You are aware?
Yes, I'm aware, but
now I am putting it to you that when the Ayinswanu results were added, all the candidates got the additional votes that they got in Ayinswanu, that's making extra gains to make the total valid votes 1, 2, 3, 6, 940. I am putting it to you.
My Lord, can you come again?
I am putting it to you that when Ayinswanu results that I have just shown you, that if you take the difference that you got from the first sheet from what they had written, you get 4189, and that 4189 on your own spreadsheet Exhibit E, it is spread across all the candidates. The only person who didn't get a gain was Hassan Ayarika. I'm saying that if you put it together, the gains that each candidate made in Ayinswanu, the total will now come to 1, 2, 3, 6, 940. And I'm putting that to you.
Yes, my Lord.
Good. Now, therefore, I am further putting it to you that the Eastern region sheet had no problem, for which you ought to have written to the first respondent.
I deny that, my Lord.
Now, I am further putting it to you that the 3 remaining constituencies that your agents, the 3 remaining regions that your agents did not sign, the petitioner won those regions.
My Lord, if the figures are in contention, we are not able to determine who won.
Now, those regions are Western North, Northern, and Greater Accra. I'm putting it to you that the candidate won at those regions when the coalition was done. That's the petitioner.
My Lord, I repeat that if the figures are in contention, it is difficult to determine who won.
Now, are you therefore saying that with respect to Greater Accra, you do not know that the petitioner won the election?
My Lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention.
You see, I am putting it to you.
And in the presidential elections, regions are not won.
Yes, my Lord. Well, my Lord. Well, my Lord.
In the presidential elections, regions are not won. There is one presidential elections and one returning officer who declares the winner at the national level. No other declaration of the presidential elections take place anywhere else.
Right. Well, I am putting it to you that for the record, Western North was won by the petitioner, and the Western North form, although not signed by your representative, it was certified by Mr. Rojo Metonunu in the strong room.
My Lord, the agents in the strong room will mount the witness box and they will be able to testify whether they signed or did not sign.
Do you still stand by your petition in this court? The petition that you filed, do you still stand by all the averments in it?
Yes, my Lord.
Now, let's look at paragraph 12 of your petition. Sorry, the petition of the petitioner, sorry. Paragraph 12 of the petition of the petitioner. Kindly read paragraph 12 to the court.
Paragraph 12. Yeah, I'm ready.
Paragraph 12 of the amended petition, sorry, my lords. Have you seen it?
Yes, my Lord.
Kindly read it to the court.
If the total number of valid votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 13,121, 13,121,101. A figure that is completely missing from the purported declaration. 111. A figure that is completely missing from the purported declaration by Mrs. Jean Adukwe Mensah on 9th December 2020, and the purported rectification on 10th December 2020.
Now, I am putting it to you that the figure in the paragraph 12 of the petitioner's petition shows clearly that the number mentioned by the first respondent as the valid votes, total valid votes, was an error, which you have admitted in your petition.
Can I hear the question again, please?
I am putting it to you that as at the time you filed this petition, you knew that the figure 13,121,111 was the correct total valid votes that ought to have been announced on the 9th, as you have said in your petition. I'm putting it to you.
My Lord, these are figures we computed from the first respondent's own data that was supplied. These are not our figures.
Well, you are bound by your petition, so let's go on. At the point that the declaration was going to be done, you have stated that your agents, Mr. Metununu and Dr. Pesakwite, left the strong room. Is that correct?
That's correct, my Lord.
I am putting it to you that they left the strong room because they realized that the petitioner had lost the election.
My Lord, I can't attest or deny that one, and these are matters in the personal knowledge of the agents who will be mounting the witness box subsequently.
And they left the strong room because they didn't want to sign the Form 13.
I can't attest to that.
And I'm putting it to you that the total valid votes as at the 9th of December 2020 and captured on Form 13 is just the same as the total valid votes in the form in paragraph 12 of the petition.
My Lord, we don't know which is the total valid votes as we stand here, because the first respondent has turned out several different figures. So our case is that Ghana does not know the results of the presidential elections as we sit here now, because the petitioner who has the constitutional duty to conduct the elections has not, the first respondent who has the constitutional duty to conduct the elections and report an exact figures has failed in that duty. So we are confronted with several figures, and it depends on what you want to believe.
Are you saying that you do not believe in the figure that you wrote in your petition?
My Lord, I stated that we picked these figures from the respondents' own calculations, not ours. We haven't supplied.
And I am putting it to you that if your representatives had not left the strong room, they would have seen that those figures, 13, 121, 111, was the total valid votes as captured on Form 13.
My Lord, I can't respond on behalf of the agents. I have indicated that one of them will be in the witness box to testify.
I am further putting it to you that 8 out of the 12 presidential candidates stayed back and signed on the Form 13.
My Lord, I have indicated that the processes within that National Collation Center are not within my personal knowledge, and so I cannot answer, I cannot admit or deny.
Now, at the time the petitioner filed this petition, he knew the results from the Techiman South constituency, not so?
My Lord, I'm not the petitioner.
Okay, we'll leave it.
Now, let me refer you to your form, your Exhibit E. Look under Bunu East. Bunu East.
Yeah.
Do you see the valid votes that the petitioner obtained?
As per the computation of the first respondent, yes. Because these are not our figures, they are figures from the first respondent.
Right. You also agree with me that the petitioner never obtained all the 128,000 registered voters' votes from the Techiman South constituency as you purport to show in your evidence. I'm putting it to you.
There's nowhere in the evidence that you propose to say that the petitioner got all. Respectfully, there's nowhere in the evidence where the witness says that the petitioner got all the registered votes in Techiman. There's nowhere in the evidence to that effect. And I think this is just to kind of mislead the witness.
Amenuvo.
Yes, my lords. My lords, I am not, with the greatest respect, misleading the witness. Lords, as at the date that the witness filed his witness statement on he signed his witness statement on the 27th of January 2021, he, in paragraph 12, sought to make analogies with the Techiman South total number of registered voters. And that is why I am asking him genuine questions based on his own documents that he has brought before the court.
My objection is very simple. He's made a specific statement that the petitioner, the petition says that all votes in Techiman South were won by the petitioner. There's no way. This talk about by analogy and so on. Let him point to where in the witness statement.
Mr. Amenuvo, please.
Yes. Now, yes, my lords.
He raised an objection. What is your response to that?
Lords, I'll rephrase the question.
Okay.
Right. Now, as at the time you filed this petition, I am suggesting, as at the time you filed your witness statement, I am suggesting to you that you could not include paragraph 12 because the total valid votes that the petitioner had obtained were known. I'm putting it to you. In the Techiman South constituency, they were known.
As at the time
you were
filing the witness statement?
Yes.
Yes.
They were known?
Yes.
Good. I'm further putting it to you, therefore, that as at the time that the petitioner filed the petition, all the total valid votes in Techiman South were known.
On behalf of the petitioner.
So I am putting it to you.
Yes.
That using all the total valid votes in the Techiman South constituency, that's registered voters in the Techiman South constituency, to do your analysis is incorrect. I am putting that to you.
My Lord, the analysis was based on what the first respondent herself claimed. So all the information there, all the figures that were stated there were from the first respondent's own account when they were declaring the results. And if I may proceed, the first respondent claimed that even though they have not had the results of Techiman South, they feel secure to proceed because even if all the votes of Techiman South were to be added to the petitioner's tally, it will not change the outcome. Yes. So the analysis we did there was to show that based on the figures she herself declared, that statement could not be correct.
I am putting it to you that the first respondent's chairperson was right, because as at the time she was making the declaration, you knew that the total valid votes in the elections was 13,121,111. I'm putting it to you.
My Lord, I don't understand the question. That I knew or the chairperson who was doing the declaration knew. Because I didn't do declaration.
You, as the witness in this box, you knew about that. I'm putting it to you.
That when the first respondent was making the declaration on the 9th, that I knew that the total figures, total of the votes was 13,121,111.
Yes, because you stated so, the petitioner stated so in his petition, but that ought to be the correct number, and the first respondent in her answer agreed with you. So I'm putting it to you that you knew.
My Lord, you see,
the question.
I don't understand why you seem to be confusing me with the petitioner. because I don't understand.
You see, that's why we have to strike out some of the evidence, because you can't speak to them. And so that's the basis upon which we have to strike out some of the evidence. And we are confirming our position.
Well, I'm still waiting for the answer.
I'm saying that I cannot answer for the petitioner. You're asking me questions that ought to be asked to the petitioner, and I'm saying that I'm not.
So,
I took these figures from the respondent's declaration.
Now,
and before they were declared, I couldn't have known what he was declaring.
Now, can you read paragraph 13 of your witness statement to this court?
My Lord, paragraph 13 of my witness statement. When the percentages of valid votes cast and standing to the names of each of the presidential candidates. On my witness statement, okay. Witness statement. Have you taken? Yeah, you've taken the witness statement. It's over there. Let me show you. Drink book. It's here. Paragraph 13. Yeah, paragraph 13. The Techima and South constituency has a total registered voter population of 128,018. And if added to the total valid votes announced by Mrs. Jane Adukwe-Mensah as cast, which is 13,434,574, the resultant figure would now be 13,562,592. Consequently, if all the votes of Techima South constituency were added to petitioner's votes, second respondent's vote will remain the same at 6,730,413, now yielding 49.625%, while the votes of petitioner were 6,342,907, now yielding 46.9%. 0.768%.
That you knew the results from the Techiman South, and therefore this analysis of yours is incorrect.
My Lord, I beg your permission to quote paragraph 12 of my statement. That will explain the meaning.
Please answer the question and then you can explain.
Again.
Answer the question. I'm saying that at the time you were making this statement,
yeah,
you knew the exact results of the Techiman South constituency, and therefore the analysis that you had made was wrongful. Answer the question, yes or no. If you want to explain, you explain.
The analysis was right because it was based on a statement made by the first respondent at a certain point in time. So if you are analyzing that statement at that point, I don't see how you bring in the current situation to be able to answer that statement.
I suggest to you that you are wrong because the current situation is the reality. The court deals with reality, not conjecture. I'm suggesting that to you.
My Lord, the current situation cannot be the reality because nobody knows the results of the presidential elections in 2020. Nobody knows in exactitude how many votes each of the candidates got and what percentage each of the candidates got. And the first petitioner, the first respondent, in her own words, and my Lord, I beg to quote in my own statement, currently, the election results we have declared exclude that of Techiman South constituency, with a voter population of 128,018. The third election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it would not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techiman. The respondent was justifying why she had to declare results based on uncompleted tally. And you are questioning that statement, that statement could not have been correct as at the time it was being made.
I am putting it to you that as at the time the first respondent's chairperson made that statement, the statement was correct and it is captured in paragraph 12 of the petitioner's petition.
I decline that.
Very well. Now, what was the source from which you obtained information to draw up your Exhibit E for this honorable court?
My Lord, Exhibit E was based on the first respondent's own data.
But you have gracefully brought it to the attention of the court. You want to rely on it. Is that also?
Yes, we want to rely on it to the extent that we want to prove a case against the first respondent.
No.
I'm comfortable, I'm a teacher, my Lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of exhibit.
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From what is?
That's the total,
yeah, the
total valid votes.
Yeah.
Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes.
Yes.
And then also for the petitioner, we have 6,265,276. Is that correct?
According to these documents submitted by the first respondent.
No. It is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way they have rendered it, that's why. 51.
0.51.
Yes. 0.51261471. Is that correct?
That's correct.
Now, I am suggesting to you that this works to a percentage of 51.2614.
A percentage of what?
A percentage of the total valid votes also on this sheet.
It's 51.263%.
That is correct.
Yeah.
Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct?
47.397. Yes.
Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned from assigned to the petitioner from that assigned to the second respondent and tell this court the difference.
Which of the numbers? You asked about percentage. You are now asking.
7. Yes, I've moved on from percentage. 6776066 minus 6265276. What do you get?
677.
It's not that good. I think you'll be stretching the witness
about 510,790.
It's okay.
Yes. It is, you got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded any votes as you allege. I am putting it to you.
My Lord, I decline that assertion.
Now, in your Exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is your allegation.
My Lord, if you look at my statement, I indicated that I'll bring a sample of the constituencies and polling stations where padding took place. I did not indicate that that is an exhaustive list of all the places where the padding took place.
Sir, we are using the numbers that you have brought to the court to assist the court. I am saying that the total of 4693 is what you have put down there. Is that correct?
I brought it as a sample. I did it in my statement, actually indicates that this is from a sample of this particular constituency. I don't understand sample to mean a total of the population.
Now, deduct the 510,790, you deduct the 4693 from 510,790. What do you get?
With all due respect, I don't see the point of the
with the greatest respect, you are being rude to the court, not to me.
Okay. Yeah, come again.
I'm saying that deduct 4693 from 510,790. What do you get?
693. I got 506097.
Good. I am suggesting to you that even if this your number as alleged, which is denied, even if it is deducted from the total valid votes of the second respondent, he still has won by your own sheet by 51.246%. I am putting it to you.
My Lord, I deny that because that you are subtracting apples from mangoes. Well, this is a sample. You want to take a sample from a population of another group. I don't see where the calculation is coming from.
You see, I am suggesting to you that you have no evidence to support your allegation, and that is why you have brought only what you have. I am putting it to you.
My Lord, we are not in court to try to declare another presidential results by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged faithfully.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I decline that, my Lord.
Now, you had earlier told this court that you cannot speak to what happened in the strong room when your two representatives were there.
Yeah.
Is that correct?
That's correct.
My lords, on that basis, I'll end my cross-examination of the witness.
Yes, my lord, I do. So, Mr. Sejun Katia, you recall that before the declaration of of 9th January 2021,
December.
9th December 2021,
Hey, Mr. Ampaw.
oh, relax. 9th December 2020, your party and your presidential candidate held a series of press conferences on what you consider to be the outcome of the elections. Is that not so?
It is so, my lord.
And in those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was, by the votes you had collated, the president-elect. Am I correct?
My lord, that is not in my witness statement.
Sorry? Where is it? Yes, the paper. So can you answer that question? You did say so, didn't you?
Come again.
I said your party, including your good self, and the first petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press. So I'm putting it to you that your party held a number of press conferences.
Yes, my lord, that is so.
Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections.
Yes, my lord.
The petitioner himself also spoke on the outcome of the presidential elections.
Yes, my lord.
And your as deputy, Tokuno, equally spoke on the results of the presidential elections.
My lord, I can attest to my statement at a forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke.
Now, you know that your presidential candidate, that is a petitioner, asserted that he had won the 2020 presidential elections.
My lord,
Ghanaians had voted for change.
My lord, what I remember the petitioner said was that the results as declared by the first respondent is not accurate.
Now, I'm also putting it to you that you yourself declared that the petitioner had won the presidential elections.
My Lord, unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that will give President Mahama a comfortable situation to be able to run the next government.
So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president.
My Lord, there were all indications that he was going to become the president.
Not indications. I'm saying that by what you said, you meant that he had won the elections because that was the only way he could form the next government.
My Lord, if I meant that, I would have said so.
See, Mr. Asedun Ketia, we served on the petitioner our witness statement.
Yeah.
You are aware?
My Lord, I'm not the petitioner.
I didn't say you are the petitioner. I said we served on the petitioner our witness statement.
Yes, I'm aware he has been served.
Have you seen a copy of the witness statement?
Yes, I've seen it.
Do you admit that in the witness statement of the petitioner, of the second respondent, we have attached Exhibit 6.
Exhibit
6.
This one.
It's ours. We are looking for our Yes, can you answer?
Yes, I've seen this in a brown envelope.
So we presume that you know the contents. So we presume that you are speaking, you know the contents of that video clip.
Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained in there.
My Lord, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at that moment giving testimony. A witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. our witness statement to discredit him. What he's saying. Now, at the time that he would have finished his evidence and stepped out, when we lead that evidence, he will not be available to respond to the content of that evidence. We want to play the video so that you will exactly. Yes, my lord. Very well. Yes.
Mr. Akoto.
Yes, my lord.
You are conducting your case, so if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. But as it is, you've not made any application. We have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
My lord, may I, with your leave, make an oral application to have the video that we've attached to our witness statement played out so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, on the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video
My lord,
establish?
The relevance is that the petitioner and his supporters or his leadership led Ghanaians to believe that they have won the election and that there was an attempt by the first respondent, together with, in collusion with the second respondent, were trying the will of the people, and that they had all the necessary pink sheets to demonstrate that they had won the elections. When they came to court finally, after a lot of pressure from the public that if you won, come to court, all they are saying is that if you use the errors in the chairperson of the first respondent's announcement, then neither party has won, so there should be a rerun. It goes to their good faith and credibility in this matter.
Mr. Ampaw, anybody at all can call a press conference and declare himself or herself to be the winner of an election. And you mean because I called a press conference and declared that I have won an election, that should be taken as the law?
No.
We have laws, we have regulations, and how we know how to declare our results.
My lords, where a major party in the republic, like the NDC, is mobilizing its...
Mr. Kutampa, you see, the witness is denying these allegations. Yes, that is why you have your witness statement together with this, would I say, proposed exhibit or whatever, served on him. If it is your time or if your time comes, then you have to put in. Yes.
My Lord, what I'm seeking to, I'm actually applying to the court for leave to play the video and use it because it's part of our case, and use it to cross-examine the witness. And my Lord, I'm saying that this is a difficulty.
You are talking about credibility. You want to establish credibility.
Yes.
Yes. So you haven't said so.
No, my Lord, I said it goes to his credibility. I said so.
You have to premise your application in the rules, and you have to premise your application in the rules of court and in the Evidence Act. That's your job. That's your burden.
My Lord, I mean, our application is relevant to this petition to the extent that it demonstrates the credibility of the petitioner in respect the credibility or lack thereof of the petitioner in respect of the 2020 presidential elections. And yes.
So what is your submission? What is your submission? What is the application that you want us to?
My application is for leave for the video.
Confront him with the exhibit?
Yes.
Okay.
Because he's been very evasive, almost to the point of denial.
The challenge we have is that you did not give any indication prior to this hearing that you want a video to be played.
My lords, it's attached to our witness statement that I believe all your lordships have copies of, and I have every reason to presume that you know that we'd like to play it.
I'm not sure whether the registry, Mr. Registrar, I'm not sure whether there is any provision made for that. Do you have? Yeah.
I was thinking
my Lord, I respectfully, I believe that we have not been heard. There have been several steps of questions and so on. We have not been heard even in respect of his basic attempt. Okay.
Submission, the application. He said he was making an oral application.
Right.
Yes.
Yes, that's why I was saying that my understanding was that the question from His Lordship, Justice Amagache, was about the practicality of implementing that.
Yeah, it has not been granted. So we have to hear you before we can rule on it.
Very well.
Yeah, okay.
My Lord, in the first instance, it is the case of the petitioner that is being made by this witness. And therefore, evidence that he says is part of their case, that evidence has not yet come in. And your Lordship will see that, in fact, literally, whilst in the box, he opened that envelope. I mean, it was clipped. I think we all saw that. It was clipped, and he answered that, I mean, he has not seen that tape. So, my lords, in terms of the answers that he's given when the matters have been put to him, he has answered those matters. Now, the question now is it is now being proposed that even before they bring in their witness statement with this flash drive, it should be put to him. That witness statement is not yet in evidence. It's not been adopted in evidence. So my lord, with respect, the procedures are simply being confused.
From this witness statement, which is, would I say, an invention into our rules. Well, you see, in some years back, before the coming into force of the, is it CI 37? 87, CI 87. Yes, you can just ask a witness under cross-examination that, please look at this exhibit. Did you append your signature to it or whatever? That was the practice. But yes, then you may even tender it through the witness under cross-examination, which was permissible. But of late, because of the CI 87, it is.
You remember, if you are conducting cross-examination, if you remember, you can pull out a document.
Yes.
And show it to the
the witness. Yes.
Yeah. That document may not be in evidence.
My lord, I have absolutely
So it's the same principle.
No, my lord, with the greatest respect, what he was showing the witness was an attachment to a witness statement that has not yet been adopted. That's very different from the...
So it is not evidence yet. It's not evidence yet.
No, my lord, with the greatest respect, I'm saying that your lordship has described a scenario which is clear in terms of the procedure, other than the procedure that is being used now. In that procedure, that evidence would not be part of a witness statement or anything like that. It would be a document that in itself can be tendered through the witness. And I don't have a problem with that. I'm just saying, my lord, and I think with the greatest respect, this is also an indication of a problem arising from the fact that the case management process was truncated, with the greatest respect. Because, my lords, in the case management process, you would normally be able to indicate these materials which you would want to put to the witness. Then in the case management process, your lordships would have the opportunity to make this practical arrangement that was being described by His Lordship Justice Amagenshi, whereby if that is a document or that is a video that they want to show and so on, that as a piece of evidence to confront him would be catered for. So, my lords, I'm respectfully making two very simple points. Firstly, in terms of the procedure that he's seeking to adopt, bringing in a witness statement and an attachment to the witness statement, that is irregular. Secondly, because that witness statement has not been adopted. So
it's not evidence yet.
Yes.
That is why they can do what they are doing. Because no longer, it's not evidence until they come to the box and adopt it. It is no evidence. So it's like they are having a document. They want to confront the witness with the document. That document is not in evidence yet.
That is why
we are speaking the same, we are on the same level. We are on the same wavelength. What they have now, even though it has been filed, is not evidence. So they have it.
Yes, but my lords, you heard him. The application that he made is that it is part of our case that so and so.
Yes.
He said that.
Yes, so it's just electronic evidence. If it were any ordinary document, he could just give it to the court clerk to show it to Mr.
Yes, my lord, as you said, we're on the same wavelength in terms of the practice related to showing a document, a video, or whatever. We are absolutely on the same level. I'm just referring to the way in which he sought to bring it in through referring to the witness statement, which is not yet in, to a witness who is under cross-examination as the petitioner's witness. That's all. But, my lord, clearly, documents can be put to the witness under cross-examination. I don't have a difficulty about that. That's why I was saying that the practical problem that we're in right now is because if in case management it had been understood And I believe that was the question that His Lordship Justice Amagashi was asking. If it had been understood that that document would be required for the cross-examination, then arrangements would have been made practically for that, because it happens to require some technology for it to be shown. So that is what I'm saying. And so we're in a situation where, the practicalities do not allow for the procedure that Your Lordship is referring me to, which I agree is a procedure that can happen under cross-examination. But because of the way that it was sort of introduced, we've ended up in this situation. So if we can, I suppose, go back to some case management and so on. And I mean,
all we need to do is to secure the equipment that can be used to play to the video to the witness. That is.
My lords, it was precisely because of this that when I got up, I sought to have directions of the court because of the new novel processes of witness statements and what it means for putting your case to
Mr. Ampaw, even if we were not in an era of case management prior, where you bring you show all your evidence, you still would have access to this through the Evidence Act. It's just about electronic evidence as compared to paper evidence. And so the system has to be set up if you apply fully.
We have actually notified the registry that we would be needing Very well. Very well. My lords, but that is why I made the application. Oh.
My lords, once you're considering these practicalities, I would like to indicate that we would, by the same token, especially once the technology is available, we would wish to have the declaration made on which he has testified and which is part of our witness team, the declaration made by the chairperson of the first respondent to be played also. We have the exhibit, so we would also, just for the sake of completeness, because whilst we're discussing all this technology, I think very well. Exactly, that's all I'm saying.
You're watching our coverage and listening to our coverage of the election 2020 petition hearing. We've got into a very interesting point in this hearing, the beginning of the trial. We have Asiedun Ketia in the box testifying. The court is back.
To the content of a prospective exhibit which has been annexed to the witness statement. As this attachment is not in evidence now, we hereby order that it should be placed on the next agenda date for us to ascertain its admissibility on the grounds of relevancy. Yes. Yeah. Yeah. My court, the petition is adjourned to Monday, the 1st of February 2021 at 9:30 a.m. for continuation of cross-examination. Yeah. Please, we've not been discharged. So Monday, they may continue to conduct the cross-examination.
Very well, man.
Yeah, I will tell you.
We are ready to collaborate with the registry to provide the necessary facilities, if need be. Very well. Very well.
Thank you for your unsolicited assistance. Thank you for your unsolicited assistance.
All rise.
Well, the first witness to mount the box to testify following the filing of his witness statement, Johnson Asiedun Ketia, is done. He has not been discharged. He will continue with his testimony on Monday. The sitting has been adjourned. Before his cross-examination, though, Nana Adodankwa Akufo-Addo's lawyer raised an objection based on the grounds that some paragraphs in Asiedun Ketia's witness statement were prejudicial.